Your Honour, I follow from my learned senior in the opening submissions for the defendant in this matter. If it may please the court, the defendant did not breach duty of care by not removing the offending party from the premises and not escorting the plaintiff safely to his car. Your Honour, as agreed by the New South Wales Supreme Court in Wagstaff v Asssignment and others 2007, the degree of a person's intoxication does not warrant a duty to remove the affected person to protect others. Further, in Cole v South Tweed Heads Rugby Club 2004, the High Court found that it must be established that the licensee knew, or ought to have known, that a patron would likely assault another for a duty of care to arise and for a breach of said duty to have occurred. Your Honour, in accordance with sections 142 ZZB and 165 of the Liquor Act 1992, upon observing the argument between the plaintiff and the offending party, the defendant took reasonable steps to stop or prevent harm by removing the broken bottle and requiring the disorderly and disruptive party to leave the premises. Your Honour, after taking this action, the defendant watched the removed party leave the premises towards their motel. The defence submits that in accordance with section 91A of the Civil Liability Act 2003, it was not foreseeable a member of the offending party would return to the premises. As was found by the Federal Court in Torts v Bryant 1988, it is not reasonable for a licensee to anticipate that a patron would assault another based on the observed circumstances. In the current matter, those circumstances being that the offending patron was observed to have left the premises walking toward the motel. Your Honour, in the final submission, the defence asserts that the defendant failing to take precautions, those submitted by the plaintiff, would not likely have prevented the plaintiff's injury. Your Honour, in accordance with section 11 of the Civil Liability Act 2003, it is relevant in deciding factual causation to decide what the person who suffered the harm would have done if the person who was in breach were not in breach. To this point, as was found in the High Court in Adil's Palace v Mobarak 2009, it cannot be established that failing to engage security and escort the plaintiff was a necessary condition of the harm caused when the offending party, who was irrationally bent on revenge and armed, re-entered the premises and attacked the plaintiff. As was the case in Tibet v Gett 2010, the High Court could not establish the defendant's failure to take action was more probable than not to be the cause of the harm to the plaintiff. In this matter before us now, that purported action is engaging security, removing the offending party from the premises and escorting the plaintiff safely to his car. Your Honour, the defence submits, as found by the High Court in Modbury Triangle Shopping Centre v Ansell 2000, that if the attack were to have occurred in a nearby street or anywhere other than the premises, there would be no possible basis for attributing liability to the defendant. To close submissions for the defence, I conclude that in accordance with Section 12 of the Civil Liability Act 2003, and as found by the Queensland Supreme Court in Brown v Holzberger 2017, the plaintiff always bears the onus of proving, on the balance of probabilities, any fact relevant to the issue of causation.